have. Today, the webinar, pre-webinar polling. I will keep the polling open for another 20 seconds maybe, so that most of you can actually fill in and have a quick discussion on the results that we have, so that we can actually set the scene of where this is all going from here. All right, let me just end the polling now. In a minute, here you go. All right, so most of them, 59%, have actually voted for both virtual hearings and in-person hearings. 20% for in-person and 14% for virtual. So not many educators of virtual hearing here, but a bit of mixed crowd. 61% have no idea how virtual hearings are conducted, which is good news because obviously this webinar should hopefully open up a little bit of knowledge flow on that. And do you think virtual hearings will be the preferred option over in-person hearing post-COVID-19? 48% believe it will be. So that's actually quite a good start to have the discussion. Now, without any further ado, let me launch into the topic. COVID-19 has been a really unprecedented time for us. We've never seen this kind of challenges. Unfortunately, it has been devastating in many, many aspects. We're all starting to accept a new normal, and international arbitration is no exception. However, in such tough times, we do see more adoption of new ideas or half-developed ideas being brought in much more strongly. I mean, this Zoom webinar is a good example. We were never using Zoom, or most of us were unaware of Zoom for many, many years. It has been around for a while. It was just something that has sprung out of nowhere and now has become a part of our lives. So obviously things are changing as we go along. Is this the case also about virtual arbitration hearings? So I'm privileged to have most eminent panelists to look at this. Timothy Cook, first, is a partner in Stevenson Harvard, is a barrister and international arbitration partner in Singapore, and co-leads the international arbitration practice in Asia. He's a leading partner in Singapore. He's a leading expert in the field, and most interestingly, he has recently conducted a virtual arbitration hearing here in Singapore. So welcome, Tim. Thank you so much for joining us.
Thank you very much.
Thanks, Tim. Nick Fell is the Executive Vice President and General Counsel of one of the largest shipping groups in the world, BW Group, and oversees the legal, insurance, corporate secretarial, and communications department of the group. So he has wide global experience in maritime and legal profession, and also represents Singapore on BIMCO documentary committee. So welcome, Nick, and thank you very much for bringing this perspective in the webinar. Yeah.
Thank you, delighted to be here, and I'm sure I'll learn a lot.
Thank you. Amitabh Jha is Chief Strategic Procurement of Tata Steel Global Procurement, part of one of the largest steel producers in the world. He has over 30 years of global experience in both trading and shipping arena, and in his current role, he has been involved in multiple areas, including, interestingly, in consolidation of raw materials, shipping, and insurance contracts centrally in Singapore. So welcome, Amitabh. Thank you so much to have you on board, and I'm sure you'll bring amazing perspective from a cargo owner's perspective as well, which is very crucial for us.
Hi, thank you very much, and good afternoon, everyone, and good morning. It's a pleasure to be here, and let's get going.
Thank you. Finally, we are delighted to have Katherine Yap, who's the Chief Executive of Maxwell Chambers, the actual place where the action, or in this case, virtual action, happens. She has spearheaded the development of Maxwell Chambers as the largest dispute resolution complex in the world, only one of its kind. She has a holistic understanding of ADR and its significance in impacting legal landscape, being particularly involved in mediation. So welcome, Katherine.
Thank you for having me here.
Thank you very much. So welcome all again, and thank you for agreeing for the webinar. One small request for panelists, since this is a mixed membership base that we have in SCMA and the audience as well, of both legal and non-legal professionals, it would be a good idea to keep the language as simple and as non-legal as possible. Let us hope the audience can take away some very useful and practical guidance from this session. So this is important that we try and impart something very, very useful, and I'm sure we will. So let me start with you, Timothy. While we do not want to get too legal in our language, I do have a kind of a semi-legal question right up. The common law system on which both English and Singapore law are based is basically an adversarial system. I mean, the key part of the case is about arguments provided by parties or their lawyers. On the face of it, this adversarial system will not work well with virtual hearings at all. On top of that, a 2018 Queen Mary University of London International Arbitration Survey found that 78% of arbitrators had never or rarely experienced virtual hearings. A lot has changed over the last 2 years and more so in the last few months. You have recently concluded virtual arbitration hearings in Singapore and also been involved in putting some guidance notes for the subject on Chartered Institute of Arbitrators. So can you just walk us through what are the key aspects of a virtual arbitration hearing and how does it differ from a conventional hearing? Just setting the base, setting the ground basically for the discussions.
Yes, I think the thing to bear in mind is that the idea of a virtual hearing doesn't mean there is just one type of virtual hearing. There can be many different types depending on the case, depending on the circumstances in each individual case. And so on the one hand, you could have a hearing of the sort that many of us have had to do in the last few months because we've had to be at home, where everyone is in their living room conducting the hearing. And that means that the arbitrators are at home, the counsel are at home, the witnesses are at home, translators are at home, transcribers are at home. Everyone is in a separate location. And that extreme situation creates its own challenges. And that's probably a scenario that we'll see less of as we move towards the end of the COVID pandemic. But at the moment, that is pretty much the norm for many virtual hearings. At the other end of the scale, you have hearings which are similar to a traditional hearing, where you would have everyone in a room, you'd have the arbitrators there, you'd have counsel on each side, witnesses attending, and so on. But one or more of those participants is being involved remotely. And there is a scale between those two extremes where you have everyone remote and then maybe one or two people remote. And you can envisage that the procedure is going to have to match the individual circumstances. And there are some practical things there. If you have everyone in a room, apart from all the witnesses, then that is going to be a hearing that is quite similar to a traditional arbitration or court hearing in the common law system, because really everyone is in the room talking to the arbitrators, apart from the witnesses who will be cross-examined remotely. But then as soon as you have, for example, one counsel who is dialing in from a different location, then already you have a perceived imbalance or difficulty to address, because you have one counsel who is remote and one counsel who is in the room. And you have to be able to accommodate that challenge. That challenge can be acute, for example, if the remote appearance from counsel is in a different time zone. And if the hearing is supposed to take place at 9 o'clock on a Monday morning in Singapore, but counsel is in the UK, so it's either 1 or 2 a.m, depending on which time of the year it is, then that can create some procedural challenges. So it's always going to depend on the type of case. And there's always going to be, a range of different issues. But it's how you manage those differences which will dictate how similar it is to a hearing or how different.
Yep. So thank you very much. I think it's, I would of course request any of the panelists to jump in if they have any comments or clarifications that they need at any time. But this is clear. So there's a huge spectrum here from being completely virtual, as in everybody not being present, nobody in the room more or less, to a point where quite a lot of them are actually in the room, but a few of them are away virtually contributing. Now, this is not something which is again new, but it's probably the buy-in has been a lot more in the recent times. So if I can then put a perspective on this, and I would just like to share a standard arbitration process chart on the SCMA side, where if we can just look at this, let me just try and see if I can get this on a slideshow mode. Yeah. So if I look at this 10-stage process for the SCMA, you have first the commencement of arbitration by the claimant. There's a response to the notice by respondent. Then comes the appointment of the tribunal by both the parties. Then you have a statement of claimant's case by claimant, and then you have a questionnaire to finish. Then you have, the respondent responding defense, and then a reply from claimant and a questionnaire to be filled out by both parties. Coming next is the proceedings, the conduct to the closure of proceedings, and then of course the awards. So traditionally, or if I understand correctly, the actual virtual hearing aspect is more relevant in terms of the proceedings, and that is stage 8 and 9. Do you actually see, Timothy, any relevance in other stages of the virtual hearing as well? Do you think that a lot of the aspects can be where virtual hearings or virtual aspects can come into the rest of the stages as well? This is to get a perspective of where it fits into the process, basically.
Yes, so if a case were to start today and parties were looking forward to a hearing at some point in the future, and they were deciding whether or not to hold that partly or wholly virtually, then it would be important for the arbitrator and for the parties to be discussing that at a far earlier stage than maybe a week or two before the hearing. In terms of what other stages this question may crop up, I think one to remember is stage 3, which is the appointment of the tribunal. It is, I think, important that parties who are interested in holding a virtual hearing, they think about who they would appoint and whether that person is someone who is confident and has some experience of running a hearing virtually, because it does require a little bit of foresight and planning in a way that's different from a physical hearing. Mainly the points that I've raised already in relation to the possibility of where witnesses or counsel and so on may be attending from. But there are other things to deal with. There's some practical problems. So, for example, what may seem like quite an obscure point, but one that can be important, is, are witnesses going to give evidence under oath or with an affirmation? And if they are, which one do you use? If the witness is in China and I'm in Singapore, do I apply the Singapore law to that oath, or do I apply the Chinese law? Now, that is quite, let's say, it might seem like an obtuse point, but it could have important ramifications, for example, in serious cases involving fraud or dishonesty, and one may want to take steps if a witness has perjured themselves. So there are aspects, it'll always depend on the case, but in my view, it should be approached at as early a stage as possible.
Getting a bit more clear that you can actually look at some additional stages where virtual hearing is also possible to be incorporated, which is quite nice to know. I'll just stop sharing this now, just giving you a bit of an idea now in terms of looking at it from a court perspective and an arbitration perspective. So if some of the parties now may be interested in actually saying, okay, we need to go to the court, we are still going to have virtual court hearings as well. And if I can just ask you to quickly go through what is the real crux, the real difference between, say, the expectations from a virtual court hearing versus a virtual arbitration hearing. What should the parties actually see as fundamental difference? I know there are procedural and other aspects, but what, if you can recap that can be quite good to get a perspective of why arbitration can be actually a suitable way of resolving disputes in general, but also virtually.
Well, I think in terms of the procedure, it's quite important because parties in litigation are going to need to still comply with the relevant civil procedure rules as they might be amended to accommodate virtual hearings. But really, the thing with arbitration that I think makes things quite flexible is dealing with the case-specific matters as they crop up. So I mentioned earlier time zones. One of the things with time zones is that it may be better that instead of having one 6-hour day running from 9 to whenever in a typical arbitration day, what you could do, for example, is have hearings in the afternoon from 2 till 5 or 2 till 9, depending, so that you can accommodate the practical difficulties of where witnesses or counsel are dialing in from. And it's that sort of flexibility which I think is very well suited to arbitration. I'm not saying that the courts can't accommodate this, but I think it'll be harder for the courts to, for example, sit late to make those sorts of accommodations. So again, it will vary, but the procedural flexibility is really where I think arbitration comes into its own.
Can I, this is Amitabh here.
Yes, Amitabh.
A bit. See, the point is the main difference as a user I see between court hearing and virtual arbitration is that there's no public profiling in arbitration. It's a very closed door affair. And whereas in the court hearing, it gets a public, you are publicly profiled because the case comes up and everybody, the whole world is aware about the case. So to that extent, of course, arbitration is preferred in commercial disputes, unless there's a stalemate and you still have to knock the door. But the issue is in virtual hearing, still the confidentiality, the closed door aspect has to be also addressed in terms of understanding how a virtual hearing can, really protect that for the entities who are in arbitration.
Sure, I get the point. And obviously a user's perspective is of course a bit more different than say from a purely legal or a counsel perspective. But we can come to that. In fact, that's a good discussion point to have, that, we have heard a lot of things about the fact that not being there physically can be a challenge for the counsel in terms of cross-examination, in terms of the fact that he's not able to get the ability to react and have that luxury of, say, changing or adapting to situations as he sees the witness or change during cross-examination. That's just one of the things. But what are the other things? And especially from a legal or a counsel's perspective, or even arbitrator's perspective, Timothy, what are the main key challenges and benefits that you see from virtual hearing, especially with the fact that there is a tremendous amount of arbitrators who probably have not got the experience of virtual hearings as yet. And of course, they will probably get that experience as time goes by. But at the same time, you really have to accept the few challenges which do exist. And of course, knowledge can be acquired, but there are other aspects which probably cannot be duplicated compared to a physical hearing or a conventional hearing. So I would love to hear ideas on that part.
Okay, I think if I can start with perspective as an arbitrator, I think I think you've highlighted just now the fact that not everyone has had experience of running a virtual hearing, and it is a bit of a baptism of fire, and something that you really only get to grips with when you do one. So having that experience is important, and that will be something that some people are more comfortable with than others. So for some arbitrators, the prospect of holding a virtual hearing is going to be something that's less comfortable to them, because they may not be used to it. They may be worried about the technology, and if something goes wrong with the technology, how does that affect the hearing? So there are those sort of technological challenges. There is also a need, and I've mentioned before, for a fair bit of planning to go into it, so that everyone is on the same page when it comes to running one of these hearings. And it's important because both parties need to have that chance to present their case. And you can see with problems like slow internet connection or a drop line can create problems which a party might try to use their advantage later on and say they didn't have a fair chance to present their case because of those difficulties. So an arbitrator has to be on top of all of those and be mindful of ensuring that the procedure as adopted and as enacted is carried out fairly for both parties. Just a practical point also, as an arbitrator, when you're doing a virtual hearing, you are juggling a lot of different balls. You are having to listen to the substance of the case, but you also have to monitor what is going on in terms of, am I getting a question from my co-arbitrator? And if so, how am I getting that question in a way that the other members of the hearing cannot hear? And how can I monitor, for example, that my transcriber doesn't need to break? A practical issue that happens in many hearings. So there are lots of other things just to keep in mind, which arbitrator is going to have to grapple with. As I said earlier, no excuse for, there's no substitute, sorry, for experience.
Yeah.
In terms of the benefits for arbitrators, my experience so far is that for whatever reason, the process does seem to be slightly more efficient. I don't know whether that's because people are still getting used to this as a forum, and so people are very focused on either the legal issue they're arguing or the cross-examination they're doing. But in my experience, it does lead to more efficiency. And I think it's related to my next point. So if I now take my arbitrator hat off and put my counsel hat on, and I talk about experience as counsel, I can tell you the biggest challenge I find as counsel is that it is exhausting doing a virtual hearing. I did a hearing yesterday. I did a half-day hearing that I think had I done in person would have been fine. But I was shattered after that hearing yesterday. I think it's because it's very intense, and you are definitely receiving fewer visual clues from your tribunal. And don't forget, there may be 3 of them that you've got on a screen at once. You're trying to sort of map and see what's going on. It is genuinely a really tiring process. And I've done 4 or 5 of these in the last few weeks, and I always feel tired afterwards, more so than I would from a hearing anyway. Another practical issue is how I can talk to my legal team or to my client during a hearing. I've tried different things in conducting hearings recently to see what works best, and I found practically having my hearing video on one device works very well, and then I have a separate WhatsApp chat with my team and with my client to deal with questions and queries as they come up. Now that takes a little bit of getting used to, because as counsel, I'm used to having someone whisper in my ear or pass me a note or kick me, and I don't have that immediacy. So there's a little bit of adjustment required in dealing with those sorts of issues. Other than that, so there's another point that you mentioned just a minute ago, which struck me, which was cross-examination. And is this an inferior mode of conducting cross-examination because I'm not able to stare down a witness and watch them sweat or deduce from a raised eyebrow that they're lying? I mean, is that a real concern from counsel? That has often been a concern that's raised by counsel in years gone by, talking about cross-examination of witnesses through video link. And part of the reason for that has been, frankly, the lower resolution of video. So you don't get to see the definition, the detail that you need in the witness and the body language. And the fact that it's always been viewed as a second best option, something that we have to put up with because the witness isn't available in the same country. Yeah. Now, because we've been thrown into this process with COVID-19, we've had to adapt to that. And I have to say, having done some cross-examination now over video link, having spoken to some other barristers about this, I'm not convinced that that concern is as well founded as it might have been a few years ago. The reality is that a lot of what we do is determining contractual disputes where the witnesses integrity or honesty is not really in question. And so the moment of reveal that you get in a Hollywood movie or Rumpole the Bailey, I mean, it doesn't really exist in cross-examination, which is a forensic exercise. It's not a aha moment exercise. I'm not sure that concern is as real. I think actually what will happen is that counsel and advocates will adapt their cross-examination style and technique to exploit the medium. So I think that's a developing thing. I'll be interested to see how that unfolds as people do more of these hearings. I've certainly had to rethink a little bit of how I might approach some cross-examination. But those are sort of my thoughts from both an arbitrator and a counsel perspective.
Absolutely. So that's really fascinating. Obviously, these are subtle changes that you need to make in how you conduct the hearing and look at it. So obviously, it's interesting to see the insights. And as you gain more experience, you obviously will have more of these sharings coming along. So hopefully that continues to happen as we go along. Now, of course, I'm still at heart a very commercial person. I've been in the shipping business for many, many years, worked in commercial shipping companies. So I would love to get the perspectives now from the users with exactly the same ideas. What do they think that the benefits of the virtual hearings are, and what are the challenges that they may face as users? I know in the pre-discussions for this webinar, both Nick and Amitabh had some interesting comments and interesting ideas that they think can be looked at. So I'll start with Nick. Nick, if you can start with your views on where this will actually take us and what are the benefits and challenges. Yeah.
Yes, thank you very much. I think from a user's perspective, this COVID crisis has given us some opportunities in that the state of technology has advanced probably 2 years in the space of 3 months. And as you said at the beginning, Puneet, we see people being familiar with Blue Jeans, Zoom, Microsoft Teams in the way that they've never have been before. I seem to use a different platform every week. But some of these benefits will definitely flow through to arbitration. Bear in mind, of course, many arbitrations, particularly in the commodities and shipping space, don't require a hearing at all. They are done on paper. So at worst, virtual hearings fill the gap between a purely paper hearing and a physical hearing. But I think that's at worst. It is likely, I think, in the next few years as the technology accelerates, which it will, the virtual hearings may become almost indistinguishable from physical hearings. I was looking at the chat just before answering this question, and a gentleman called Jagmeet Makir raised 3 issues of time, cost, and privacy. And I think the time and cost are on the benefit side rather than the negative side for virtual hearings. One of the big criticisms of arbitrations has been that originally they were meant to be a more informal, commercially led environment, but many of them are morphed into something that's more or less indistinguishable from a more formal court environment. And I think virtual hearings may actually push the balance the other way. Definitely become cheaper. They'll become cheaper because people won't need to travel, and you won't need to physically meet and rent a building and all those kind of things. I think they'll be cheaper because, in terms of time, because there won't be so many delays. Calendaring will be easier. One of the notorious difficulties in arbitrations are getting, if you've got more than one arbitrator, the 3 arbitrators to coordinate their calendars. That is going to be, by definition, I think, much more easy in a virtual hearing environment. The location of witnesses, same thing. Bit difficult now to argue for a party to argue, my witness is in another country, very difficult for him or her to travel. Not the case anymore. Timothy raised a very interesting point about the style we see in arbitrations and of certain counsel, and indeed parties' behaviour. Some, and we may know some, are very theatric in the way that they present their cases, and in some cross-examinations as well, banging the table, trying to find the killer question. And I think you will see a different style amongst counsel, which will become more forensic, which will suit some and not suit others. Some of the challenges are going to be the concentration risk that Timothy mentioned. It is very difficult to have a seminar or an intense hearing or anything online for more than 2 hours. And I think that you're going to have to see an evolution towards bite-sized chunks, which will be a different mode, a more interesting mode, actually. And also the robust technology. We've all had these big meetings where you can't hear somebody or the technology fails. Yes, that's a risk, but as I mentioned, the technology is improving all the time, so that risk will reduce. I don't think at the moment virtual hearings are very good for big, complex, multi-party arbitrations. Let's start it fairly simple and see where we go from there. And I agree very much with Timothy that the immediate feedback that you get by being in a physical room is going to be a bit absent. But I want to say that, oh, and one other challenge I think is that, going back to the concentration, I looked at some studies and 60% of people who are not actually videoed but are participating in these kind of conferences and so on, and indeed arbitrations, are going to be doing something else. They're going to be twiddling with their Instagram, eating, those kind of things. So again, I think the concentration risk is probably the largest. But let's face it, the two of the most important Supreme Courts in the world, both the UK and the US, have swung into action and are now hearing almost exclusively video hearings. And the judges are saying it is fantastic and it's working very, very well. And if they have those sentiments, I know we can, and we will have a good experience. And indeed, I've been through quite a lot of training as mediator, where we're talking about mediations being virtual, and the use of breakout rooms and those kind of tools, which will help parties smooth along arbitration and have side conversations. I think Jagmet also raised privacy. And again, I think it is a real concern, because all too easy for me to have a recorder right next to me or a camera and record the whole proceedings. So I'm not quite sure how we get around that. And for particularly sensitive arbitrations, there may have to be a different regime in place. So from a user, I think that's what I see as the benefits and the challenges. Yep.
Very interesting. So much. I think it's very interesting to see the point that you mentioned, that home office is not really office, and that's something that a lot of people tend to neglect, the fact that you are never going to be 100% concentrating. You are going to be having distractions all along. At the same time, I also believe, although now most of the homes do have, and they're all scrambling to get the best connectivity, but in traditional situations, offices have better connectivity, or actual places of work have better connectivity than homes. You were never really paying very much attention about how many gigabytes per second connectivity you had. So now suddenly you're going to have to work from home much more. You need to start thinking about the actual hardware, which I think a lot of people are not yet ready to look at. But I'll just move on to Amitabh before getting to this part. Amitabh, if you can just enlighten us with a little bit of your comments. I know you had a different take on this in terms of some of the soft aspects of arbitration, which I think you said can be lost a little bit in the virtual scenario.
Yeah, so most of the points have been taken care by Timothy and Nick. Cost is one aspect in favor of virtual arbitration. Concentration, not in favor of arbitration, virtual arbitration. Consequence and confidence. So I'm trying to see if I'm an affected party and if I have to do a virtual arbitration, what is my confidence? What is my arbitrator's confidence in accepting a virtual arbitration? What is my management's confidence in accepting a virtual arbitration route? So unless we have seen with so much of mixed experience and reviews, we have to see whether it will be effective or beneficial for me. So for example, I sit in Singapore, I have a team of arbitrators, my counsel sitting here. However, the other party who is outside is on a virtual basis, but we all can gather in one room and do a virtual arbitration. So there's a disbalance in the whole approach. And if I'm on that side of the table where I see the other party is sitting all together, of course we are virtually connected, there is a disadvantage, inherent disadvantage to the arbitration. So we need to have an equal playing field. While we are addressing an issue of challenges and debate on arbitration.
Sure. And obviously, I think the breakout that you mentioned also is an interesting idea, that you're really in a virtual scenario. You are obviously, that's part of the privacy that is also coming into a subsector of the privacy that Jagmeet talked about, that obviously it's going to be difficult to do those kind of breakouts and make sure that you're able to take a cohesive decision or an adaptive reaction to something that has just happened. How quickly can you react on a virtual side? In a conventional side, you can probably take a break or a signal or whatever needs to be done to get somebody's attention. But here you're going to have a challenge doing that. Would you say that that's a challenge for sure? Yeah.
Yeah, that's the challenge, because it's like playing a video game versus playing a real game. You're sitting in a room and arbitrating, discussing. The atmosphere is very different. Now here we are going to play a tennis or an arbitrate without spectators. That would be a totally different thing. You know, so yes, conventional arbitration sets up a mood, puts pressure on everybody to take a decision. This timeline, expenses are involved. Of course, they are higher, but people are more conscious of it. They want to conclude it fast, which all can be missed out in terms of a virtual arbitration.
Sure. Absolutely. And we will take a rounded view on this, but in order to get a rounded view, and especially with connectivity, I think I can bring Katherine in now with that perspective, because obviously this is where the actual action is happening. And obviously we are all of the unison that it's a great idea. We should actually save cost and time, but we are all having inhibitions or apprehensions about connectivity and a whole bunch of other things. So Katherine, can you just guide us through what actually happens? And we are talking about real action, virtual action happening out there. You have been equipping yourself for this, and this is like a dream come true in some ways, although it's a nightmare for most of the people. But let's hear from you what Maxwell Chambers is looking at in terms of providing this service. Yeah.
Well, if I can just sum up what Timothy and Nicholas has mentioned earlier, we can categorize three types of hearing. One is the physical hearing space, which is the more conventional way, whereby everything is set up like the screen behind me. You just have to walk in, everything is ready. And we have a 140-inch LED TV right here. So you can talk about very clear resolution in high definition in terms of looking at each and every one of the parties. Now, the second one will be the hybrid virtual hearing, where most of the party will be located, let's say at Maxwell Chambers, and then remote parties will be bridging from overseas, for example, like United Kingdom, Europe, US, Australia, and China, for that matter. And then we talk about the full remote virtual hearing. I think this is where Timothy was touching on earlier on, which proved to be, I think, somehow a great difficulty sometimes for my moderators, because we do provide for all three different types of hearing. So for the recent remote virtual hearing, although we had a moderator on board whereby they will scrutinize the parties, whether they have muted accidentally or muted their video accidentally, and they will be talking for hours without realizing that they were muted. So the moderators play a very important role. They have to be attentive. They have to be very aware what's going on in the meeting room, unless they were asked not to be present. Then of course, that's a different story altogether. And again, they are able to video the entire process, so that helps as well. But we need them to sign a disclaimer to say that, yes, I would like this session to be recorded, or no, I do not wish for these sessions to be recorded, and they do not need a moderator. So these are some of the forms that we have provided for our users to ensure that they know what they are in for. And if they choose not to have anything video, we have to ensure that nothing is being videoed. So we talk about the security and all that. I can't promise all the multiple remote parties have high connectivity. So the bandwidth recommended is about 100 Mbps. So that is the recommended bandwidth for your Wi-Fi connectivity. So it is also mentioned to me that sometimes house Wi-Fi fails you as well. So what do? Then you have no choice but to use your iPhone or your Android mobile devices, use your hotspot. There is another way. I have a party who used their hotspot, and surprisingly, it gave very good Wi-Fi connectivity. And many a times we were told that, could it be our platform that we are using that is not stable, and that is why people are like booting out from the entire virtual hearing? But I beg to differ. I think it is everybody's responsibility to ensure that their connectivity is running smooth. Because I just would not want to mention any country, but there is one particular country, I think it's a rural area. So the connectivity on their end seems to be very low. So what happened is when all the parties started questioning about the platform, there could be an issue with the platform and all that. But we have the back end to show everybody's connectivity, the bandwidth. And we realized that that particular country has a lower bandwidth, and that was the whole reason why he was booted out. So I think every parties must play their role to ensure that they have good connectivity. And I would recommend to have a earpiece. Try not to use the Bluetooth ones, because sometimes the battery fails you and you also lose in some loss in transition. And the plug-in earpiece with microphone is the best, because they kind of block out all your environment and all that. A suitable room, everything starts coming to play. And if you talk about connectivity, it is better if you can hook with the Ethernet cable directly plug in. I think that would give you a better quality connectivity.
Okay. Thank you. That's very practical. You also, I believe, have created some very simple videos on YouTube.
Yes, I did.
To kind of give people a flavor of what it is in a very simple way of how to conduct and go through this hearing. So obviously you have one already up and ready, and you're planning more as you go along. So if you can just share a little bit about that as well.
Part 2 and part 3 of the tutorial is supposed to be out last week, but of course we are trying to fine tune a little bit of part 2. What we are providing is we have been going through a lot of webinars, having myself and some other of the ADR centers coming out to talk about how do you set up, and getting ready for your virtual hearing. So for Maxwell Chambers, I think instead of hearing people repeating themselves at webinar, we thought that if you have a YouTube tutorial like how you get your recipes from, it will be good. And what we do over at Maxwell Chambers is every time you engage our services, we will prep you with a checklist. So the checklist will be forwarded to you so that you will know that, okay, you have everything ready, the lighting, the camera, whatever you have, everything is ready. We'll do a test run for you. So the moderators will go through step by step the test run just prior before your actual hearing. So that's what our moderators does. And also we do have some clients or parties who have difficulty even to maneuver and navigate their own computer. So with their permission, we are able to take over the control of their computer. It's no rocket science. It's just a service that we render. So we will just go in and help you set up your BlueJeans or your Zoom, which is one of the more stable platforms that everybody is using at this current moment. But talk about security. We do have our own server on site at Maxwell Chambers. So we have firewall, layers of firewalls after firewalls to secure our Wi-Fi connectivity. So that Maxwell Chambers deliver that promise that your Wi-Fi connectivity and the firewall is up, so it's secure. But we can't promise, the platform that comes along with it, like Zoom. There was a recent news report that Zoom was being hacked. In fact, come to think about it, I think it was about a month and a half ago. I probably think that they could have resolved it by now. So, but then again, everybody feels that Zoom is the platform to go because quite honestly, for BlueJeans, we use them very often because of the stability. But for Zoom, I think we use them because it's so user-friendly. I believe a lot of parties has to agree with me. It's so user-friendly. And you can look at 50 parties at one point. And I thought that was wonderful. So these are some of the pros and cons you have to look when you want to have a certain platform that you'll be using for your virtual hearing. So we have also tied up with, we have started an alliance with in Canada, the Arbitration Place, and IDRC in London. This alliance is really to assist all parties to facilitate a smooth and seamless hybrid hearing.
Okay, that's very interesting. So obviously we'll hear more about it. There are lots of questions rolling in, and I will be taking them one. I think what Jagmeet's question was already answered by Nick, but I'm sure I'll get the rest of the panelists to also answer it. But before that, I have one final question from my side. And this is more kind of a conceptual question, open to all of you guys really in the panel. Do you actually think the virtual arbitration hearing will actually mean the end of relevance of a particular arbitration venue? So are we heading now to a truly global arena where you can pick and mix, for want of a better word, the arbitrators, counsels, witnesses virtually to get a hearing sitting in your own offices and homes? Will it actually be relevant or matter at all to have choosing Singapore or London or Hong Kong as the arbitration venue? I mean, does it really have a role to play? And this is more from an understanding of a kind of, let's take a crystal ball and look at where this is heading. Is there any relevance now? What does the venue itself offer if everything is virtual? So all of you can actually start. Maybe Timothy, you want to start with your comments on this, and we take it forward.
I think in terms of the legal seat of arbitration, then that'll always be important. But in terms of people choosing where to have a hearing, I think what will happen in future is going to depend on the collective experience of running these virtual hearings, and whether the collective feedback is that it's a positive way to proceed. And different people are going to have different experiences, but I think some of the points that my panelists have already raised point in the direction that we are going to see more and more hearings conducted virtually, either wholly virtually or certainly a greater component will be heard virtually. And I think that's just reflective of a realization, because of the situation that has befallen all of us, that it is possible to conduct hearings in this way, and that in many cases, I think there is no detriment to the integrity of the process or the way in which parties can present their cases. They may present their cases in a slightly different way, but I don't think that necessarily the process is degraded because we are having to adopt a process which is seen as inferior to the holy grail of an in-person hearing. So I think that as more people are exposed to this, I think they're going to realize there is an element that can be revisited. I think particularly in relation to witnesses who are overseas, who are currently have to fly in and give evidence for half a day and then go back again. Those sorts of costs and inconveniences are probably going to be a thing of the past. I know there are some questions about cross-examination, credibility, and so on, and I'll deal with those perhaps at a later point. But I think many of those can be addressed adequately through appropriate sort of directions from a tribunal, including also concerns about privacy. There's another lot of questions on that. Again, I'm happy to discuss those in a bit as well.
Sure. If I can get Nick and Amitabh to come in as well, and maybe Katherine eventually, to talk about this idea that is the place of hearing any important at all? I mean, I know legal seat of arbitration is important for other reasons, but is there any sanctity or is there any relevance now of having a venue only in Singapore, London, or Hong Kong? It can be anywhere in the world, Nick, isn't it?
In theory, yes, but I think it does come down to three things. It comes down to the appropriateness and the modernity of the rules of the particular arbitration venue, no matter where you're going to hold the arbitration in the cloud we're talking about. But the rules are very important. Are they fit for purpose? Are they updated to cater for things that we haven't imagined that will come out of problems that may come out of virtual hearings? So nimbleness in rules is important, and I know that Singapore will be the vanguard of that. Second thing is costs. Of course, arbitration centres do compete vigorously on costs, and that I've noticed has become a more and more important feature on selecting where you're going to have your arbitration. And the key one is credibility, which Amitabh mentioned. Which arbitration centre are you going to feel is going to give you a fair shot? And Singapore is poised brilliantly for that. We all know that.
Absolutely, sure. Yep, Amitabh, some comments from your side as well in terms of what is the future of the relevance of actually having a specific venue agreed for arbitration? Is that going to go away as important as it is today? You're still mute, Amitabh. Yeah. You're okay now.
Yeah. No, it's not going to, relevance will not go away of the venue for sure, because you have jurisdiction and venue play a very important role in your arbitration. Yes, how you conduct a virtual, 100% virtual or semi-virtual, that is a question only time will decide, because one side can still arbitrate that I want to do a physical conventional arbitration, and the other side will say I want to go virtual. So that will become another point of arbitration to start an arbitration. However, I think on cost side, there's a lot of pluses. I would say that whether it's virtual or conventional, I think we will start with a mix of both. And as people get comfortable, I think it will evolve. Overnight, I don't think virtual could overtake conventional, because you need a lot of confidence, credibility, and mindset issues.
Sure, absolutely. Right, noted that. And Katherine, of course, it's good news for you that virtual arbitration is going on. And by providing the facilities, you already have a relevance established with regard to Singapore. So that's appreciated. Any other comments you would like to add going forward? Are you actually seeing any feedback from the users, for example?
Yes, in fact, we have been talking about, virtual hearing being the new norm, but I personally foresee that there are also clients and practitioners who will resume physical hearings when the situation gets better. For example, over in Singapore, the phase 1, where it's going to be lifted pretty soon, we already have increased number of inquiries asking us whether can we send our mediators and our arbitrators, for you to facilitate a virtual hearing, bridging with other parties. So we do have that many inquiries asking about that, the preparation to open our center again to have physical hearing, the hybrid hearing, sorry, my apology. So having said that, it is also, I read an article from HSE that it is recommended for a 5 to 10 minutes break for every 50 to 60 minutes on time spent on computer. So I was wondering whether does the ADR virtual hearing practices that? Because if they don't, then prolonged view looking at the computer or electronic devices gives you a headache. I don't know about the rest of the parties, but I usually get very bad headaches at the end of the day after staring at my computer for hours, because and not forgetting that all the parties are presenting their cases. Amidst that, I think it is quite difficult to focus after some time. What about those breaks that you need to go to the toilet? You need the toilet breaks, the water break. All that has to be taken into consideration. So I think based on the recent poll that you have just conducted, I can see that there are still 20% over the 17% who still prefer in-person ADR case. So I think it's too early to say that is this going to stay like everybody will do it remotely? I think I have the same question. I wouldn't know. But to take a question from Damien Yo, he was asking, because we were doing some collaboration with Opus 2, and we are also looking forward to working with other providers as well. So for future proof of Maxwell chambers, I think until the heat sensor comes in, then perhaps the parties will be more at ease, having questioning the witness and making sure that there's nobody within the room. So with a heat sensor, so I think these are some things that can be explored and have some research. As Damien, if you are aware, Maxwell Chambers is always on the lookout for technology to improve ourselves and all that. So perhaps we may look into some Internet of Things, IoT gadgets to perhaps have some heat sensor, heat detector. I'm not quite sure, but I heard about this heat sensor and detector being developed at this current moment. So I hope for the best, but some of the things that we have, the one thing good about Maxwell Chambers is we have extra large room that can accommodate all the 1 meter distancing. So I think for that, we will be expecting more and more parties coming back to use the premises and perhaps do the hybrid virtual hearing. That's my sense.
Absolutely. So this is great, and I can vouch for it that the facilities are top class. The virtual background in behind me is the Maxwell Chambers Suites, where our offices are, and I can tell you from all the experiences so far in a very short time, it has been quite remarkable to see the facilities. So I can turn to the questions now. I think we've already answered Gerald's question about virtual hearing and cross-examination, body language, demeanor, and also we've answered Jagmeet's question about time, cost, privacy. The next question is from an anonymous attendee. Assuming that arbitration had commenced and one of the parties is located outside Singapore with more than 12 hours time difference, does the arbitrator need the agreement of both the parties to conduct the hearing in virtual mode? So is this a mutual consent thing? I usually believe party autonomy is quite high on the agenda. So Timothy, would you answer this question? I presume it will need to convert from a conventional to a virtual arbitration. You would need both parties to agree?
Well, the answer to that question may depend on the legal seat of the arbitration and what powers the arbitrator has. So many countries that have adopted the Untitled model law provide, and that what the model law provides is that the tribunal has a very broad discretion on how to conduct hearings, and many institutional rules provide that it's the arbitrator who, in consultation with the parties, will determine the appropriate procedure suitable to the case. So the tribunal will have a very broad discretion, but it does give rise to the practical question which has been asked, where you have a party that is appearing in New York in a Singapore arbitration, for example, then what is going to be the most appropriate way to take evidence and hear submissions? And is it going to be appropriate at all for there to be a virtual hearing? If the tribunal feels it is appropriate because maybe for cost reasons, there's no need to fly counsel and the witnesses out from New York, then the practical issue is what is going to be the fairest means of taking that evidence and how. And the time difference will be an important factor in that to make sure that it's fair that one party is not giving evidence or is making submissions at midnight. Though that said, it will be down to what may be agreed with the parties and what the tribunal feels is best procedurally for the case. So in a case, I sat as arbitrator at Maxwell Chambers just as COVID was shutting down Singapore. We had a mixed virtual hearing, and I had counsel from one party in the UK. Other counsel was in the room, and the UK counsel argued the case that week at 2 a.m. until 7 or 8 a.m, his time. And that was agreed to be by the parties to be appropriate in those circumstances, that counsel was willing to do it. And there's no suggestion that it was being unfairly done as a result of that. But if the tribunal is going to be ordering something like that against the wish of a party, then of course there is then going to be potentially a risk that there could be a challenge to the award later on the basis that that party didn't have a proper opportunity to present its case. That's the fear, of course, that this could be abused for those sorts of types of application. And so arbitrators do have to be careful when making those sorts of decisions.
Right, thank you. The next question comes from Kapil Dev Behel. I believe Mr. Behel has recently been empaneled in the SCMA panel of arbitrators. So welcome, Mr. Behel. Thanks for your question. How does one ensure the witness is not in contact with or not being prompted by others? And there's a similar question from John Gibson. How do you ensure witnesses, including experts, are not being prompted? From John Gibson. So I would say these are kind of practical challenges. Probably the ground is too early for us to be able to get to that stage where we can even try and tackle these challenges. But have you practically faced these things, Timothy, and how have you kind of looked at that, for example?
Yes, I have come across this problem. In some cases, this is not going to be an issue, but in other cases, parties are going to be concerned that a witness needs to give his or her own evidence without prompting and so on. Now, practically speaking, the way this could be done, and again, you have to tee this up in advance. One way you can do this is that you make sure that the camera on that particular witness shows not just their face, but has a decent amount of coverage to show the desk, whatever, in front of them as well, that has their witness statement on. You can ask, and I've done this, you've asked for the camera to sweep across the room, excuse me, to show who else may or may not be in the room. Again, in many cases, that is sufficient. Where parties or tribunal is concerned that there may be some interference, another option is to have a second camera in the room that shows the whole room from behind the witness. So you get two views to ensure that there's no one else in the room and that the witness is not on their mobile phone receiving messages, and that the evidence they give is indeed their own. So that's a practical way that you can try to address this problem. Another way is by using facilities like Maxwell Chambers or IDRC in London or arbitration chambers. Those facilities, I don't know, the expectation is probably going to be that if a witness is in Singapore but is giving evidence remotely in respect of a London arbitration, then it may well be that then in London the arbitrator says, well, that witness in Singapore can give evidence in Maxwell Chambers in an environment which will be secure and everyone will be satisfied of the integrity of that. So that's another possibility we might see developing from the different institutions and the different arbitration centres to offer those sorts of services as well.
That's interesting, and I'm sure Maxwell Chambers also equipped to do that kind of thing as we go along. So I will just take that as a given. Karine Albers, who you all know is also a panel arbitrator for SCMA. I think first of all, she comments, I think first of all, it has to be mentioned that 80% of cases are done on documents only. Secondary preliminary hearings, interim hearings, case management conferences are much more suitable to be conducted via virtual hearings. So good comments. In addition, we have only just started for the last 3 months, which is correct. No one can expect many arbitrators to have conducted so many virtual hearings. Yes, 12% have conducted only one virtual hearing, another 12 have conducted 2 or more. So there's a few more than what the survey was at least there. And of course, the home Wi-Fi is a challenge, which obviously she's talking about as well. And experts have been cross-examined by video link for many years, and depositions have often been conducted by a phone where they cannot even see the expert. So this is not something new, I agree. All this is good comments, Karina, and obviously they're all issues that we have grappled with in past. I just feel that, as I mentioned, the scope of use or the amount of use of these technology tools has simply gone through the roof. And that is where the concern really starts, because we do have people talking about these challenges, but they were kind of distant, or at least partly not visible. But today they are in front of us, and that's why we need to do something about it. So yes, these are challenges, but yes, we have some experiences that we can draw from in past as well. I've got a question from Subra. whom I know as well as my previous professor of law. A question for Timothy. I'm familiar that role of the demeanor of a witness during a trial in court can have significant impact on judges' assessment of the credibility of the witness. Body language and subtle visual cues inevitably furnish a judge with advantage in assessing credibility. But it does appear that there are differences in assessing credibility in a criminal trial or in matrimonial proceedings as opposed to commercial trials. Do you think arbitrators similarly focus on such issues as demeanor? So even before we differentiate between virtual and face-to-face arbitration, aren't there already differences between credibility assessment in a trial as opposed to an arbitration? So he's just trying to put together this idea about what role judge plays, and do you think a similar role is played by an arbitrator as well with regard to demeanor?
Good question. I think that arbitrators do take into account the demeanor of witnesses. The extent to which it meaningfully impacts how a tribunal decides a commercial case, I think, is far less than in a criminal case, where very often questions of the integrity of the witness or the honesty of a witness is in question. Now, and I mentioned this earlier, many commercial cases that we deal with, and many shipping cases, don't involve the integrity of a witness at all. They are contractual disputes, and witnesses are really there to assist the tribunal with what happened at certain stages. The circumstances where fraud is alleged or the witness is impugned in some way are less common. But of course, where there are those cases where fraud is alleged, for example, then yes, arbitrators do, I'm sure, take into account demeanor. It may well be that in those sorts of cases where those sorts of allegations are raised, people will be more comfortable having an in-person hearing. It's nothing to say that that can't be possible. So it may be that some cases it's just not suitable.
Sure. But also, I guess in some cases, you may find that the witnesses sitting in the comfort of their homes or offices or wherever they are sitting would be in a much more relaxed position than, for example, sitting in a face-to-face hearing. And that would also guide how arbitrators see the testimonies and the statements of the witnesses. Don't you think that has a kind of impact which is not really legible, not really tangible, but an intangible way of kind of making the witnesses more comfortable? So the parties may actually push for virtual arbitration hearings because they feel that the witnesses will be much more relaxed at home rather than bringing them face to face in a arbitration hearing.
Relaxed witness isn't.
Yeah, it's okay.
A relaxed witness is not necessarily, from counsel's perspective, a good thing. In fact, it raises the particular experience I've had, which is that, as you say, witnesses in this format do appear sometimes to be more relaxed. That's because we are using Zoom for so much more than virtual hearings. We're using it to speak to our families and our colleagues and so on. And so there is a certain level of your guard being down doing these sorts of Zoom calls. Now, I think that is an element of advocacy that people are going to latch onto. I've seen it done recently where counsel, very clever counsel, used that dynamic to become that witness's friend and unpick their evidence in a very, very convincing way. So it was used by the advocate to their advantage. Of course, from an arbitrator's perspective, that might not always be the intention, because arbitrators want to get the best evidence from a witness. And if they're more relaxed, then I think usually that's more likely to happen.
Sure. I think, Nick, you had some comments on that as well. Did you?
Yes, I was going to say that I think you can see in the future, people will ask, litigants will ask, because of the cost savings, why wouldn't we do a virtual arbitration? In other words, it will be the default rather than unusual. And one reason for not doing a virtual arbitration is exactly these issues we're discussing: fraud, the way you want to cross-examine certain witnesses. We all know law is a fairly conservative domain, and we also know that necessity is the mother of invention. And indeed, the last 3 months have shown that the law is perfectly capable of catching up. And I would expect this to continue post-COVID.
Right, that's a valid point. Another question now from Amit Oza, my elder brother, also in the shipping business. Thanks, Amit, for attending. He is basically talking about a suggestion of trying to create a virtual arbitration limited by value. So like the small claim procedures that we have in various arbitration association, how about limiting virtual arbitration by values? I guess this is like documents only kind of a hearing. But if the value amount involved is quite low, then virtual arbitrations can be a default setting, as you mentioned, Nick, rather than a unusual setting or a option. So that can be an option, but I'm sure that people are thinking about it, and CMA definitely should start thinking about it. And I'm sure we will be discussing this going forward in terms of how to best serve our customers and users with virtual arbitration hearings. So thanks for that. David Chang has asked in relation to PDPA. Hold on, have I got it here? Just one moment. Yeah, in relation to PDPA, that's the data protection aspect and recording. Would there be any breach where the session was recorded, but the participants did not realize this, and he was not provided any prior consent? So this is more a procedural thing. Rules need to be drawn up to make sure that whatever needs to be done is done properly and by the procedure. Timothy, you mentioned to me in the pre-discussion that there are some practice documents which are available now, which maybe the parties can actually look at.
Yes, there are two that I think are really worth looking at. The first is the Seoul Protocol on video conferencing, which was developed some years ago to find the most efficient way of conducting taking evidence by video conference. It's a very, very helpful document, has some technical matters towards the end which are extremely useful. But as a document is a very good checklist of sort of things to watch out for. And then also there is the Chartered Institute of Arbitrators guidance note on remote hearings. That's slightly broader in scope because it's not just dealing with video conferencing of witnesses, but also the whole gamut of virtual hearings. And that has a number of items in there that are really should be looked at, I think, by any arbitrator who's thinking of conducting a virtual hearing, because it just contains some sensible information, and at the end has a checklist as well. So that document, for example, does raise the spectre of security, and I don't recall it mentioned specifically issues of PDPA, and I don't know the answer to that question. But those are the sorts of things that are going to have to be addressed by tribunals as and when they're raised by parties and of their own volition as they prepare these hearings.
Absolutely. Right. So obviously that's something which is, but it would be a breach, I guess, in that case, if we have not got the consent of the party and you end up recording and breach privacy, then that would be a challenge in itself. I presume so, yeah?
Conceivably, I think that it may well be, yes, if it's done without consent.
Sure.
Just to reassure parties and people who's participating in this webinar, we don't record unless we are told to. And on top of that, they need to sign a form to ensure that they know what they are getting into. So that is the assurance from Excel Chambers.
Okay, that's nice to know. Captain Rohit Bhatia is asking whether CMA is looking to formulate rules for online arbitration. Yes, we are looking at that, and that's a project which is ongoing. So that's obviously on the agenda for us as we are working on. Jagmeet has got another question, which actually is also similar to what Kapil Dev Bahel has got. What about an arbitration clause for virtual hearing? Do we need to incorporate new clauses in contracts Nick, I know you had some ideas on that, but also Amitabh and Timothy, you can chip in and basically say, do you actually see the need for having a contractual clause to amend for virtual arbitration hearings than the conventional clauses would you have at the moment?
I think, I mean, arbitration clauses are, as we know, quite varied. Some excellent, some not drafted badly, some long, some short. I'm sure there is scope for specifically referring to virtual hearings, but I think it's more important the rules of the arbitration body cover that eventuality. That's what I was talking about before when I was trying to say that it's important, if you're going to be a leading arbitration centre, to keep your rules up to date.
Okay. But I guess there's really no clause as such that we've got going on at this point of time. So I think most of the time it's about the actual centers and their own rules that they need to draft up. But that's obviously a discussion point that will come up. Another question is, can the arbitrator deny one or both parties' request to conduct hearing in virtual mode? So is an arbitrator able to kind of go back and say, sorry, but we will not do a virtual hearing even though parties want to do it? Is that something which is even done? Or Timothy, in your experience, any such denial of requests?
Well, again, subject to the law of the arbitration, the tribunals tend to have a pretty broad discretion. But if the parties have agreed that they want to conduct an arbitration virtually, then it seemed to me with that consent in place, it would be a bold arbitrator that would override that and say otherwise. But there might be occasions when he or she does do that because they feel that it's not in the in the best interest of conducting a fair and efficient reference. I think it would be a very fact-specific exercise in each particular case to work out how a virtual hearing would take place. And don't forget that there may be what would be a virtual hearing is going to go somewhere along that spectrum that I mentioned at the start, between fully virtual, everyone in their living room, and at the other end, one or two people participating remotely.
Sure, absolutely. Right. So obviously we are coming close to the end of the webinar. We've got another 5-10 minutes go. Can we just launch a couple of polls very quickly to get some feedback now, after having done this basic discussion and a little bit more practical discussion? Can we actually see some polling on the same questions, but are you any better off than where you were at the beginning of the hearing, or the webinar? So we can start it. There you go. After listening to this webinar, would you advocate for virtual hearings or in-person hearing? And after listening, do you have a clear idea of how it's done? And do you think this will be the preferred option after COVID-19? So I'll keep it open for another 30 seconds. And hopefully we will have most of the people. We got about 117 participants online. So obviously it's a good gathering, and I'm sure we will get a lot more people participating for the next 15 seconds. It would be good to have that answer. Okay, I'm still seeing both as the answer to the first question. Still very much great. Okay, I can end the poll now. So where we are, of course, is that 60% still advocate for both, which was the kind of the similar situation before that. They have a clearer idea of how virtual hearings are conducted. So Katherine, good news for you. 100% of the respondents who have responded have said that. And 43% have said that virtual hearings will be preferred option over in-person hearing. So that's really, really good to see. We have one more poll, which is a feedback poll, which we will send out now as well. And I don't need to share the results. That's just for our internal use within SCMA. This is our very first webinar. So we would like to actually have as much responses as we can. And of course, we would love to get in touch with you if you're not I see a lot of members of the SCMA, panel arbitrators, a whole bunch of people whom I know. It's great to see so many well-known faces. I won't say faces, but at least well-known people in the audience here. So that's great. I'll just quickly end the polling in another 10 seconds for this one. And then we have, yep. That's good to know. Most of them are very positive about this. That's very nice to know. Appreciate that. Now, of course, there are a couple of questions which we do have. Is just quickly run through this before, I think just a couple of them actually. One is, of course, do we have any information, Timothy, of time frame taken for virtual hearings till presentation of award for cases that have been handled in the last 2 months? So is it a quicker process? Do we have any idea about what are the time frames here?
I think it is too early to say.
Okay.
But just because conducting a virtual hearing is one part of a much longer process, as you identified earlier, and the writing of the award is still going to take the same amount of time. I think the question is whether holding some or all or part of it virtually will compress the overall timetable. Again, I think it's a little early to say. We'll have to see.
That was John Prasad Menzies' question. Thank you so much, Ms. Menzies, for that question. And Jeffrey Bloom has a question saying that does or should the formal versus informal dress code of all participants make a difference to the perception or seriousness of virtual proceedings? So his take is we should all be dressed formally in a physical hearing. So obviously this is something which is quite crucial in some cases, in some, I would say, jurisdictions or areas, but not so much in certain areas. What's your experience been on dressing in a virtual hearing?
Hugely varied. I've been under and overdressed in different occasions. So yeah, it's still not clear which way we go. I tend to overdress on the side of caution. All
right. Well, I think we'll call it the end of the Q&A now. All I can say is that this has been a really fascinating discussion. It's been a very informative session for me and SCMA as well. It's been successful. It's been a very well organized event. So I thank the SCMA Secretariat for all their help, and Vinny and Michelle for the help as well. And mostly, I'm very, very thankful to all the panelists. I think this was really an amazing discussion where we actually got a chance to get some practical inputs, but also some conceptual ideas as to where this is all headed. A bit of crystal ball approach, but at the same time, we're also looking at what we can do tomorrow morning, which is different from what we did yesterday. So thank you so much, and have a good evening and a good weekend, and stay safe. Thank you very, very much. Thanks a lot.
Thank you.
Thank you.
Thank you.